Our next panel will discuss the ever-elusive supply chain disruption and opportunities. Here to moderate is my good friend and neighbor, George Tsimis, a maritime and commercial arbitrator, marine risks consultant, and sanctions specialist. His panelists are Catsambis, commercial manager of Eurobulk Euroseas, Carol Hand, corporate counsel for APL Logistics, Aase Naaman Jensen, senior vice president and head of the New York office of the marine insurer Skuld, and George Kontakis, a partner at the global firm of K&L Gates.
Thank you for that kind introduction. I'd like to thank everyone at the Hellenic American Chamber of Commerce and the Norwegian American Chamber of Commerce for inviting me to moderate this panel, which will be addressing the legal aspects of supply chain issues that the maritime world and the world at large has been experiencing since the pandemic came into our lives, and arguably which pre-existed, but which were exacerbated during the pandemic. Our topic, the specific topic, is supply chain disruptions and opportunities. So by that title, we have some good news and bad news. And the bad news is the disruptions, the good news are opportunities. We're going to start off with the bad news, but before we do that, I'd like to introduce our illustrious panel, which consists of a knowledgeable, experienced, and specialized group of individuals from the maritime shipping community and also legal community. We have 3 lawyers and one who's not a lawyer, who's going to keep us honest, but provide us with appropriate statistics and perspectives to keep everything short and simple for all of us. We're not going to try and get lost in the legalese here. So our panel consists of Aase Jensen, who is the head of Skuld's New York office. Aase, who, by the way, is also a fellow Fordham Law graduate, which I'm very proud to say, as I am. Aase is going to provide us with the insurance perspective, and she also had some experience back on the operations side for a container ship operator, so that's going to be very helpful. Carol Hand, who is corporate counsel at APL Logistics here in the US, where she advises all of APLL's business lines ranging from NVO, CC to freight forwarding and consolidation services. So that's going to be very timely and appropriate given all the difficulties that we're encountering here in North America. Catsambis, who is the commercial director at Eurobulk Euroseas, 2 publicly traded shipping companies in both the dry bulk shipping space and also the container ship operations space. So he'll give us the ship owner perspective. And George Kontakis, a partner at a major law firm here in the US, K&L Gates, and part of their partner in their maritime practice group. So again, we have a stacked panel, and let's just dive right into the topic. We've all been hearing for the past 2 years or so since the pandemic began as to how supply chain stresses have increased dramatically. We're also just coming off the holiday season where we were all wondering whether or not our online orders were going to make it to their destinations in time before the big day, or if they were going to be stuck somewhere between China, the west coast of the US, or the east coast of the US. In this context and with these disruptions that we've all been facing, I'd like to ask Carol, in her capacity as counsel at APLL and as a logistics specialist, to kick things off here and to try and summarize for us what type of legal disputes and legal challenges she and her colleagues have experienced during the past year, and in particular, the types of disputes, the legal disputes that she and her colleagues have been facing. So Carol, if you could kick us off, it'd be much appreciated.
Great, thanks, George. I appreciate the introduction. I will say, I sort of want to start, I joined APLL about 7 months ago, and prior to that, I was actually with an ocean carrier with Ocean Network Express. And so I think one thing that is interesting to focus on is right at the outset of the pandemic, and as you said, there were already congestion issues, but right at the outset, one of the big immediate concerns was going to be, we're starting to see more and more delays contractually, what is that going to do? I'm sure everyone who's in the maritime industry and in logistics has, sort of heard ocean carriage is not an exact science, and therefore delays, no ocean carrier is going to agree to be liable for delays, and, even delivery several weeks after, after the projected deadline is still a good delivery date. But this has obviously been an extraordinary circumstance. So where ocean carriers may have had clauses in their bills of lading or their contracts that say we're not liable for delay, you're suddenly moving into a much further out area that is sort of previously unexplored. So there was definitely a question of, will there be liability for delay, and what will that look like? As an NVOCC, so moving over to my time with APLL, we obviously face those same questions. And as an NVO, we are actually in that fortunate position of both being a shipper in relation to our carrier, but also a carrier in relation to our customer. So we're facing challenges on both sides. We are facing, how are we going to be handling these delays, and how will our customers deal with those, and what's in our contracts and our bills of lading. But also, how can we try and work within the contractual confines of what we have with our carriers and their bills of lading. So that was one of the big issues right off the bat. This will come as a surprise to absolutely no one listening to this panel who has been involved in the maritime industry. The big challenges we face on both sides are needing space and trying to, we've got our customers coming to us saying, please just find me space anywhere. So then we are then in the position of having to do what we can to try and find space for them based on our existing contracts or new ones if we can pursue those. And obviously, even if you have space available, can you get the cargo back out of the terminal once it's been delivered, if it's finally been offloaded from the vessel? So there's just delay after delay there, and trying to determine, how we can get those picked up as timely as possible. So there's always a big issue of availability, and that comes back again to the contract and bill of lading. If an ocean carrier or terminal says, oh, your container is available, but we send someone to the gate and they can't get in, and it is actually behind a locked fence, from our perspective, that's not available. And then you're going to see disagreements about what the availability of a container may be. So coming very much to your point of what are the basic disputes, that's the number one dispute is, get my container, get it available, and what are the charges associated with that? So again, probably not a surprise to anyone who's been involved in maritime recently. The biggest disputes are going to come back to demurrage charges, detention charges, and those types of who's going to be liable for those charges. Because we know the delays are happening. We know someone's going to be charged for them. How is that going to fall out? And so you're going to be looking to your contracts, your bills of lading, et cetera, to see who's going to be responsible for those. And obviously this is it is a contractual and a commercial issue, but it also stems and gets back into more of, we get into a regulatory framework, which I'll talk about in just a moment. But as far as how we as an NVO are going to try and address those disputes and try and minimize our exposure, we're going to negotiate with our carriers and potentially even with the MTOs and marine terminal operators, and see what we can do to try and get some mitigation or some relief. That works the first few times. If you go back to the same carrier over and over again, they tend to get a little less willing to work with you on that. We also, will have times where we can try and sort of, especially after the FMC's interpretive rule came out, threaten to go to the FMC with claims of unreasonable demurrage or detention charges. And that's one thing. While I was at ONE, I saw a lot of increase in disputes of folks referencing back to that interpretive rule.
Right. Well, Carol, you mentioned the FMC and regulations, and obviously that's another role that you have to play as in-house counsel. But what can you tell us about any recent regulations or steps that the U.S. government has tried to take or implement to address these supply chain disruptions?
Absolutely. So, and starting back as far, probably longer than this, but most people probably remember the congestion in 2014, 2015. So the FMC has had their eye on congestion for a long time, particularly on the West Coast. And because this is a big money area, that's where there's a lot of focus. And it has been building for a long time. So the FMC started with their fact-finding, followed that up with an interpretive rule, which then obviously is not a legislative rule, it's not legally binding, but it does give guidance to the carriers and the shippers and everyone else in the industry to what might be reasonable practices. And as a follow-up on that, again, many people may be aware, we finally had this OSRA, so the Ocean Shipping Reform Act of 2021, that was passed by the House in December of 2021. And so that is now currently before the Senate and actually in committee with the Senate. And that's definitely something that both shippers and carriers are going to keep a close eye on, I'm sure, going forward. And just to touch on a couple of quick issues, since I know we are a little bit short on time, it does very much sort of look back to the interpretive rule and try and start codifying and bringing some of those rules to be more enforceable. It does prohibit retaliation, and that's a big issue you see, because a lot of shippers are really uncomfortable with the thought of bringing a claim against a carrier. Although I will say one of the things I've seen is because these demurrage and detention charges are getting so much larger, people are more likely to challenge them because they're feeling it's a much bigger exposure than it may have been when it was just 1 or 2 days of demurrage versus 60 or 70 days.
Right, and it may just be like at the same time, it's worth it to challenge it just because of the size of the claim at that point, correct?
Absolutely, yeah, the size of the claim, and also ASRA gives a little bit of an extra hook, because historically, while there's been no retaliation, people were still uncomfortable, but this further puts the burden on the ocean carrier, and this will be the last point I'll make here, of justifying the reasonableness of their charges and making sure that if there is a claim before the FMC, they have to prove and show that these are reasonable charges and that they're not charging the shippers unreasonably. So that is another big change in how ASRA would impact how demurrage disputes are going on.
Thank you for that, Carol. Well, that was the NVOCC, which again can sometimes be a hybrid role where you're also acting on behalf of shipping interests or the shippers. I'd like to turn now to Adam so that you can give us from the ship manager, ship owner perspective, Adam, both on the dry bulk and container side. Perhaps you can give us a bit of a summary of your experiences during the last year that you and your colleagues over at Eurobulk and Euroseas have experienced in the context of these supply chain disruptions. What can you tell us about this?
Well, thank you, George. The areas where we've seen disruption in our operations are mainly four that I want to touch upon. The first and foremost is crew movement. Immigration regulations worldwide differ from one to another in the same country sometimes. We have quarantine periods imposed in various parts of the world. Even airlines might have different requirements for crew travel between them. So the role of the crew manager in his effort to try and keep the crew changes up to date is a very challenging one, and every day has to solve a very complex puzzle. Having said that, the vessel needs to follow the charter's commercial instructions, and the schedule is determined by the charters in the port where crew changes can be made so that the crew with expired contracts can be repatriated. If the charter schedule doesn't allow for crew changes, we have to deviate the vessel and go to a port where crew changes can be carried out. An unscheduled port call, however, could possibly incur quarantine periods at the next scheduled port of call. So we have often disputes with charters that come up, especially if they want to order the ship to a port where crew with expired contracts cannot be on board. However, the schedule doesn't allow them to be repatriated in the meantime. We're trying to work with our charters, we're trying to cooperate, we're trying to build into our charters clauses like the new BIMCO COVID crew change clause that allow us to unilaterally deviate to change the crews. However, it is a complex situation, and it's not being resolved as we
I was going to ask you about the BIMCO crew change clause. Has that gone smoothly with your charters? Has that worked to your satisfaction as a vessel owner?
When push comes to shove and somebody has to pay for the delay, no, it's not smooth. We're trying to work together. We're trying to explain to them that we need to carry out crew changes, otherwise we might run into trouble. And with the charters that we work with closely, we usually find a way around everything. It's mostly actually the sub-charters that create issues because they have the ship usually for a trip or so. So it's more difficult with them. The second area where we were facing issues is travel of surveyors, both our own surveyors who need to visit the ships and make sure that the plant maintenance is ongoing, and outside surveyors that need to renew certificates or carry out surveys. Sometimes it's difficult to arrange such calls. And we had an incident on a ship where a class survey was scheduled. The certificates were expiring. We had to have a class survey on board. And the day before the ship arrived, the surveyor contracted COVID. so he was not able to attend. And it was a big struggle to get an extension from the class to the certificates, otherwise the vessel would have to stop. The third area where we're facing issues is the spares and machinery forwarding. Spares, as every industry knows, are hard to come by these days. Forwarding is a much more complex operation requiring planning much more than it used to. A critical spare arriving late might mean that the vessel can be rendered unseaworthy, or even could be stopped dead on her tracks if you have machinery that's broken down and you can't forward spares. And the last area is the uncertainty of regulations and unclear lines of authority between the different bodies. We had the case where a ship arrived in the port of discharge. One of the crew members was running a low fever. He underwent repeated COVID tests, all turned out negative, and the port authorities cleared the vessel to berth. However, the terminal operator refused berthing of the vessel. They wouldn't accept the vessel alongside. We ended up in a stalemate. After 20 days or so, the charters diverted the vessel to a different port of discharge. There was an overall delay of about 25 days, and it ended up in a dispute with charters of close to $1 million. So in this environment of high rates and unexpected delays, things can get out of hand very easily.
I can imagine, and unpredictability is not a vessel owner's friend in these situations, especially when time is money. You touched on seaworthiness, which happened to be our topic for last year's legal panel discussion. So it's clear that issue is still in play and part of the problems with supply chains. And but yeah, thank you for that, Adam. It's a good segue now in for us to ask Aase from her perspective as a P&I club representative, especially as the head person in their office in the Americas. Aase, perhaps you can give us a little perspective as well on the types of situations that Skuld's members have encountered during the last year that are supply chain related, and also if there's any kind of particular types of legal disputes or challenges that your members have come across during the last year. If you could relate that, we would be much appreciated. Appreciate it.
Well, similar to what Adam sort of just referenced, then a number of the issues in the supply chain that we have come across are certainly related to, or should we say, triggered by some of the many challenges resulting from COVID. And I mean, on the P&I side, we've seen many cases such as those described already by Adam, relating to, amongst others, crew, survey inspections, and port regulations, and the many, should we say, different requirements that some of the ports choose to change and update from time to time, which makes it difficult for the various members to actually comply with, and certainly want to keep up with continuously. On the FD&D side, it has particularly been focused on issues such as delays in all its aspects, should we say, both inquiry pre and post fixture. So it has been, delays in the sense of disputes in terms of deliver into or redeliver of a vessel after a charter has come to an end, or delivering into a new charter. It could be delay in delivery of the cargo itself, as Carol also sort of mentioned, but certainly also issues such as delays of getting pilots on board the vessel, demurrage and detention while the vessel is waiting for different reasons. And general focus on congestion overall, because it's sort of the crux of it all in terms of how the member is positioned under the charter party and under the bill of lading. And it really is the allocation of liability under the charter party and bill of lading terms that much of it boils down to, and the right in regards to whether or not you can actually off-hire the vessel or interruptions to late summer demurrage. But we've certainly also come around it in regards to rerouting options, if they've fixed the vessel already, or the opportunity to do so if you're about to fix a vessel. Effectively, different efforts to bypass and avoid congestion around port closures. So effectively to minimize the waiting time that they might have or be exposed to in the ports that has already been elected under the particular charter party, for instance. So that has been alternative ports or additional ports or geographical rotation, for instance. or deviations under the charter party, whether or not it actually does constitute a deviation, or whether it's whether the charter has a right to do so or order the vessel to go to a particular place. But it can also be waiting en route because much of it has also caused some financial outstandings here and there in terms of some not effectively having paid up because it has gotten to be substantially more than what they anticipated that the outstanding would be at the end of the day. But also just the payment disputes that has simply increased continuously over the last long period of time between the different contracting parties. So a good mix of all of the above has certainly been the result, both on the P&I side and particularly a P&D side.
Well, when you say good mix, it made me, when you were telling us about delays in delivery, it made me flash back to my P&I days when you had matters that started out as pure FD&Ds and might morph into a P&I claim with delayed delivery and breach of the contract of carriage. Have you been seeing that type of morphing of existing claims into more complex P&I claims?
Certainly, or the other way around, that you start out with what perhaps is a relatively simple cargo matter that all of a sudden morphs into a highly complex dispute between the charter party or under the charter party, between the owner and the charter, or even a tri-party where you have the voyage charter below and where you have a time charterer who's also the disponent owner under the voyage charter party. And certainly is not on back-to-back terms, which on the FD&D side can then be a complex situation in terms of what rights you have up versus downwards. So yeah, absolutely.
And the last follow-up, have you had any FD&D matters, or, well, it would be FD&D presumably, involving the BIMCO crew change clause?
Yeah, I think it's safe to say that it starts out as one clause, and then you see it sort of slowly change over time in terms of how the different parties tries to sort of manipulate it in one or the other direction, to either under the argument of making it more or less balanced, all depending on who you ask. I think it's safe to say. Interesting.
Well, thank you for that, Aase. And now that brings us over to George. George, as someone who's just the pure maritime lawyer here, where you're the gun for hire and you have your clientele and a large clientele, especially in the shipping community, what kind of situations have you come across, or have you seen, or what has there been any prevalent type of legal dispute that you have been asked to assist with during the past year on the supply chain side?
Well, first of all, thanks, George, and thanks for inviting me to be part of the panel. I greatly appreciate it, as well to the Hellenic and Norwegian chambers. I feel like a little bit of a poster child for it, given that on my father's side, I'm Greek, and on my mother's side, I'm Norwegian, so it's sort of perfect. You know, as far as claims are concerned, you know, obviously all of this is stemming from COVID, right? COVID has just really, you know, interfered with everything. We all know that. And it's led to sort of new and different claims as well, you know, stuff we wouldn't have seen before because of the way we're trying to address COVID. And it's different everywhere. Every port, every country is handling it differently. Some are more strict than others. I think a great example is China, of course, which has had very, very strict COVID policies. As a matter of fact, we've had a claim recently for a Skuld member, one of Aase's friends. And that particular vessel came in to load. They're loading bagged cargo. The Chinese, with their strict policies, have a so-called no-touch policy. They will not touch the cargo. And as a result, the cargo was essentially dumped into the holds. So extremely poor stowage. And at the outset, there was an argument, there was a discussion, there was fighting with the stevedores, and there was delay, right? And so we keep seeing these delays. Whether they're small or big, it doesn't matter. Every ship loses, let's say, an 8-hour shift, and you add that up by thousands of vessels, you've lost thousands and thousands of working hours just to add to the supply chain, you know, disruption. So in that case, they load the cargo. Of course, they load short. Under the charter party now, there's a dispute for dead freight. So we have a dead freight claim. The ship sails to the discharge port. They get there and they're still fighting about the dead freight. Of course, then the owners threaten a lien over the cargo. They don't want to discharge. Another fight ensues. More delay before we offload the cargo. Thankfully, the lien wasn't asserted and we moved forward. But by the time they finished discharging the cargo, it turned out there were less bags than were on the bill of lading. So now we have a claim under the bill of lading for short discharge. So it's, as sort of Aase said, these things tend to morph and continue. Of course, this particular matter is much more complex than just the bags.
I think you got Willis's attention there with a short cargo claim, a shortage claim.
So it never ends, but this is all, again, it goes back to COVID policies, how we're handling things, and the sort of, kink in the chain that comes from that, that's leading to delays and further disruption at every port and on every vessel. To speak to sort of Adam's comments about crewing issues, I've been involved in a number of S&P deals as well, and we have found that delivery of the vessels has been a tremendous challenge. Where are we going to off-sign the crew from the sellers, and where are we going to on-sign the buyer's crew, and find a port where we can do this with the nature of the restrictions, the nationalities of the crew, the visa status, the logistics of bringing them in by plane and quarantines. It's really complex. So we had a matter, and I'm sure we'll be speaking about this shortly because this is on the opportunity side, where a client looked to buy a vessel to deal with supply chain issues. We found the right delivery port, at least we thought we did. Under the MOA, we had an agreement for an extensive handover. Because of COVID restrictions, we weren't able to put any representatives on board. So we had no one on the ship. The ship arrived for delivery. We needed some time for a handover. Of course, the problem with that is the on-signing crew are stuck in a quarantine facility. And the moment you pull the trigger to pull them out after 8 days of quarantine, they have to go straight to the ship. And if there's any delay in actually closing on the vessel, that crew has to go back in the quarantine center and lose another 8 days, right? So it's very, very tricky, and there's a lot of money and time at stake. The off-signing crew, who were asked to stay on board to do a handover, if they don't leave the vessel immediately and go to an airplane, they get stuck in a quarantine facility. So these poor guys, as Adam has said, have been sailing for a year. They finally see the light at the end of the tunnel. It's time to get off the ship, and they're being threatened with quarantine. And so in that particular situation, the off-signing crew refused to do the handover. We had a very short handover. It was technically a breach of the MOA, but there was really nothing we could do logistically. Otherwise, you have to put all those genies back in the bottle and wait another 8 days plus. So very, very complicated issues. And again, further delays, right? If a party says absolutely not, and you have another delay and you lose 8 days, it's another 8 days that vessel's not working. And again, it just compounds across the fleet. So I think that's why, we see the disruption just getting so horrific, because all of these little pieces added together create significant disruption across the entire supply chain. So I think those are two good examples on claims.
I assume that when you went to law school, you had no idea that you would also have to be a choreographer to try and time all these pieces to jibe and work out time-wise, which can be very, very challenging when you're dealing with different jurisdictions and different regulations.
For sure.
So I think that the first half of our discussion, which we're finishing up with the bad news now with the disruptions, has what we can take away from all this is that, as you say, George, it affects every single aspect of the trade. And we can expect this type of a knock-on effect to continue, at least in the immediate future. But let's see now if we can shift gears and move on to the next topic, the good news, and discuss opportunities. And because you elected to defer taking the ball in the first half, George, you're starting off the second half with this discussion. Sorry, I have a little NFL playoff football still in my head after yesterday. But what can you tell us about opportunities? I mean, when we talk about opportunities, we're talking about what the context that we're looking at this from is you have all these players that are in this industry that are members of the supply chain, and they're trying to either take charge, take control of their own destiny, and either reshape their supply chains to improve them as to what they had, or in some cases, recreate them entirely. What kind of experiences have you had in the past year where one or more of your clients might have had that kind of strategic decision-making where you advised them?
Sure. So it's been quite interesting. Obviously, with the supply chain disruption, so many cargo interest and charterers are, looking for opportunities to make things better, right? There's significant challenges with getting cargo to the shelf, getting their product to the shelf and making their sales. And the unknowns in part, and I think Carol's experiencing this, just not knowing when is that cargo, when is that box going to get out of here and get to my shelf and get to my customers? When's that going to happen is killing them from a business perspective. So I've had a recent client come and say, we want to buy a ship. We want to purchase this vessel. We want to move our own cargo. We're tired of dealing with the containers, the unknowns, and the crazy pricing. So this has led to, an opportunity here to reinvent their supply chain. And in this particular case, they were fortunate. The cargoes that they had were already palletized, but going into containers. And so by having that availability, they were able to shift from container shipping into palletized cargo shipping. And we went out and we found them a tween decker that allowed them to load as many stacked pallets as possible. We acquired the vessel. We set up the logistics provider in China. We set up a logistics provider on the West Coast, a vessel manager, and they have pivoted into becoming their own ship owner to move their own cargo and take control over their supply chain. The benefit of this for them is that they have, by using a multi-purpose tween decker, they've avoided container terminals, container ports, and the congestion, right? So they found an alternative port. So far, so good. The vessel is actually loading for her second trip in China right now. And each time she's basically gone directly to the berth with no waiting time, which is, obviously a huge, huge benefit compared to what we have seen in the container space.
Well, thanks for that, George. And it's fantastic that you're able to assist them in that respect. I want to turn to Aase quickly. We are running a little bit short on time. Aase, what can you tell us about the same types of inquiries you had from your members? And perhaps maybe we can dive a little bit into the types of documentation that go along with this type of recreation of a supply chain or an improvement of a supply chain. Oh, you're on mute. There we go.
There we go. So like George, it's been interesting to sort of see and positive to note how the difficult supply chain challenges of the industry sort of in some parts have triggered some companies and for us members to be willing and able to sort of think outside the box of the classic trade that they have traditionally been engaged in and foster new ideas as to how they and their company can optimize their operation and be more flexible, if you will. So as an example, then parties who were previously only engaged in dry bulk, for instance, we now see that they are engaged in container trade by using dry bulk ships. So a shift such as carrying containers on dry bulk ship is not done overnight. It's a process where you obviously need involvement from both class, hull machinery, P&I, and so forth, because it is both a substantial physical as well as operational sort of aspect of doing that shift or making that shift, as well as on the contractual, legal, and insurance side of things. So while we on the P&I side, of course, lean much to sort of say, well, have you gotten approval from your class and have you gotten approval from your hull machinery? Then obviously we are amongst others looking into the documents, as you also mentioned, because if we just take a traditional dry bulk carrier, then he will perhaps issue one bill of lading for the entire load that he has on board his vessel. But if you're shifting into container trade all of a sudden, one thing is that you will probably need more than just one bill of lading for whatever you have on board. You will need to look into your contract to CP clauses. What is your clause paramount say? What is your bill of lading clause saying? Who is issuing the bill of lading? And what form of bill of lading do you intend to issue? What is the liability scheme of things? Are you allowed to actually carry on-deck cargo? And do you have a condition survey for the purpose of actually carrying containers? Then we're back to the class approval again to some extent in terms of cargo securing, what type of cargo are you actually going to carry, and how is it going to be loaded and secured, and what equipment do you actually have on board, or where do you intend to discharge in terms of loading the containers and discharging them again? How is the vessel actually equipped in terms of loading gear and manuals and so forth? So it takes much more than just a good idea to get to the point where you actually execute that brilliant idea.
Not
So
just as
hats off to
simple as
the ones who
putting
do it.
containers on a ship, right? You still need to get your paperwork in order. You need to clear things with your P&I Club with class and make sure you get legal advice, right? That's the recommendation. Carol, how about you? Can you give us a couple of quick, just in a couple of minutes, can you just summarize for us what you've done to try and find opportunity in all of this disruption?
Absolutely. So obviously not every shipper, as much as George may love if more shippers could come out and buy their own boats, not everybody has that ability. So as a 3PL, one of the things we're able to do is provide a plethora of services to support our customers. So one of the big things we see is a lot of our longstanding customers where maybe we're providing one type of service, they're expanding into our other services, and we can provide them support on an international basis. So if they were primarily doing consolidation, we can now start to explore doing, NVO services or freight forwarding services. So the big opportunity for us is expanding those relationships and also obviously taking on new relationships. So people will reach out to us if they're unable to make the solutions happen themselves. They'll come to us and we'll see what we can do from that perspective. And so the second part of that is also trying to expand our vendor relationships. So we have obviously existing ones with various ocean carriers, rail, truckers. But this is, as more opportunities are coming up, we're going to explore other ways to try and utilize the services that are out there and available, and maybe enter new contracts or explore new services that might be available from even existing carriers we're using. And then the last point I would definitely think is worth making is George mentioned the whole unknowns. And so a big thing as a 3PL is because we have visibility across the entire supply chain. We have a product that's called Data Guaranteed, and that way people can plan well. You can actually track your freight as it's moving. And that's always something people have wanted to know. People track their Amazon boxes from the moment it leaves the warehouse. But now it's critical for planning purposes. You need to know when it's going to be available. Can you get somewhere to pick it up, get it delivered, et cetera. So
it's an analytics world, right?
So we can use all of our existing services.
More information, the better.
Yep, absolutely.
Okay. Well, Adam, the last word for you. Do you see containers on bulk carriers having any major effect on these disruptions?
Thank you. Definitely, we're living unprecedented times in the container trade. And just to show the magnitude of the rise in the rates, the top 10 operators who report financial results, and that excludes MSC, who is now the largest operator, had reported combined in total. In 2021, that same number for these operators would be in the region of 120 billion. So the rise is tremendous. And under these circumstances, obviously, anybody in possession of a floating object would like to load it with containers and move them around. In these circumstances, many bulk operators try to convert their ships to carry containers, but as Aase mentioned, it's a very complicated process. It's not easy to do it. It's a long process, so you don't even know if the market is going to be there at the end of the day. We've seen a few cases. We've seen a Cape size loading 1,600 boxes or a few Supras or Handys, but in a total of 800 million boxes moved worldwide every year, that's a very negligible percentage. So overall, I think there's some diversion to multi-purpose ships, but a negligible percentage that doesn't really affect the market overall.
Thank you, Adam. Well, I'm going to have to make that the last word. We're going to have a question and answer center, a question and answer session pretty soon. But I just wanted to say, first of all, thanks to each and every one of the panelists for your participation here. It's been an honor and a pleasure. And we look forward to hearing any kind of complex questions or simple questions from our audience. And once again, thank you very much. Okay, well, we've had an interesting discussion, and now it's time for our questions and answer session. Our discussion on opportunities somewhat got shortchanged, so I want to ask a quick question to George Kontakis and just ask him to run down for us quickly. If someone's contemplating reconsidering or reinventing, rather, their supply chain, George, what are the steps that you believe they should take in order to do so?
Sure. I don't think we have enough time in this brief session to go through all of it, but I'll
Just
give
in
you
a couple of minutes, yeah. I
quick
don't mean to
summary.
throw that
So-
all on you. Like,
Yeah. So I think first of all, you have to sort of, I do four things. You need to identify the problem, right? You need to then identify the solution, formulate a plan, and then execute, right? And when I say identify the problem, I think that what I've experienced with the clients is they really need to focus on what are they trying to solve for? Is it the costs? Is it the time? Is it the opportunity cost of not having the product there? Or is it just strictly control? They want to know that they know where their cargo is at any given moment. And I think that helps them to then talk about what's the solution, right? And within that solution discussion, it's a combination of understanding what you're trying to solve for, right? Don't create additional problems for yourself. Make sure you're solving the problem at hand. And then what can you really do with that cargo? And I discussed the one opportunity where a client was able to pivot from containers to pallets. I have another client who happens to own their own containers based on the type of product that they have. So they're still focused on containers, but looking for ships that can carry containers, non-traditional, let's say, not necessarily bulk carriers, but multi-purpose type vessels. And I think that that's extremely important to what are you going to do next steps, right? Because you have to identify the type of ship. And so when you come up with formulating a plan, sort of step 3 here, the key is really getting the right service providers across the board, right? So you need to start with a good technical manager, because as you talk through these cargo issues, you need to know that the types of vessels you're going to look for can actually do what you want to do, right? So when you're loading pallets, you can't necessarily use a bulk carrier. You need a tween decker in order to maximize cargo intake. Or if you have containers, you need to make sure that you actually can do the container intake that you're looking for. So securing a good technical manager to help you work through that stuff, I think, is important. Obviously, you need a good S&P broker to work with you in identifying the vessels. And then one of the things that seem to be the biggest challenge is, cargo interests are unfamiliar with the whole logistics part of this. I'm very used to working with freight forwarders where they, say I have cargo and a container shows up and they pack the container and off it goes. Now you need to look at what are my options for getting cargo from plants or warehouses to the port, to loading the vessel. How are we going to load the vessel? How are we going to secure stevedores, the right berth, et cetera? So you need to identify good logistics providers on both ends who can work with you to go through that process and make sure you can reinvent the supply chain. And then you need to execute, right?
and we're running a little bit out of time.
Yeah, sorry.
No,
yeah,
that's fine.
execution's negotiating all those contracts, obviously having a good lawyer.
You need to get in touch with a good lawyer. of course.
Exactly.
or qualified people at every turn. P&I
Correct.
Club, logistics consultants, and of course, the client itself. So on that, I just wanted to pivot to one last question. How long and this is for each of you, and obviously it's going to be a quick response. How long do you expect these stresses to continue in the supply chain? And what do you believe will be the one major contributing factor that is going to alleviate these stresses? So we'll start off alphabetically. Let's go with Aase first.
My luck. I think it's going to take a long time. And I think both COVID and, as I think a previous speaker today said, the change pattern by consumers in terms of how we actually buy will influence how long time it's going to take. But I think it's impossible to guess and look into the crystal ball and say how long time it's going to take. But I do think that flexibility and more creative outlook in terms of how it can be resolved will be necessary.
Thank you, Aase. Adam, you're next. What are your thoughts?
There's definitely not a single factor that is causing this situation, and no single factor is going to resolve it. We have to see how shoreside logistics are going to be sorted out. Terminal planning has to come back into place so the congestion can be reduced and eventually eliminated. And these are all complex issues that will definitely take a long time. I would guess the better part of this year, for sure, before we start returning to any sort of normality.
Thank you, Adam. Carol, what are your thoughts?
Well, I'll have to sort of reiterate what's already been said. I don't think we're looking at an end anytime soon. And I will say, I do think we're going to have this whole new normal. And so I think there's a high probability that things will never go back to sort of how they were. And if you look at the past, there's always been ups and downs and congestion issues and challenges in the supply chain. So the simple question is really going to be, how does that manifest going forward? If we have a new influx of vessels because everybody had all this additional capacity coming, or the need for capacity, how is that going to look in the long run? So I think it's just going to be a very interesting time to stay in this industry. Yeah.
Thank you, Carol. George?
Yeah, I think it's going to go on for a while. I think that we have seen a number of very, very large players make some very big moves over the long term. And I think that's an indication here, with large companies chartering their own tonnage for years, not just for temporary fixes. I think that the view from many is that this is a long-term issue that's not going to resolve itself overnight. So I do think it will go on for a while. I think, obviously, again, to go back to COVID, right? COVID is causing a lot of labor issues and creating a lot of this disruption in all of the ports, as well as on board and dealing with the crew. So I think, we have to get past the pandemic in order to have, more efficiency across the entire chain. And until we have that, where we're not going to be interrupted by, sudden shutdowns and lack of labor and people calling out sick, et cetera, it's not going to resolve itself. And then once that does go away, it's still going to take time to get that kink out of the chains.
Thank you, George. Well, I'd like to thank everyone for participating. It's been a very stimulating discussion. Lord knows legal disputes will continue, but I hope that we've shed some light on it for our virtual audience and for each other. And with that, I will turn things over now back to John Stratakis, fellow Long Island resident, maritime lawyer, and organizer within the conference. So John, over to you. Thanks very much.